Welcome back my YouTube channel NDS Shorthand. Please like, share and don't forget to subscribe the channel. So 5 seconds to go. Start. The first point arises out of a contention raised by learned counsel appearing on behalf of the first respondent within bracket hereinafter referred to as the respondent, that the presumption under section 4 of the Prevention of Corruption Act 1947 applies only after a charge is framed against an accused and has no application at the stage when the court is considering the question whether a charge should be framed or not. It is said in geometry that a point has position but no magnitude, but we are constrained to observe that this point raised on behalf of the first respondent has not only no magnitude but has even no position. It is wholly without substance, and indeed it is surprising that it should have been raised by the learned counsel appearing on behalf of the first respondent. When the court is considering under section 245 subsection 1 of the Criminal Procedure Code whether any case has been made out against the accused which if the difficult to understand as to how the court can brush aside the presumption under section 4 of the Presumption of Corruption Act 1947. Subsection 1 of Section 4 of that Act provides that where in any trial of an offence punishable under Section 161 or Section 165 of the Indian Penal Code or of an offence referred to in Clause A or Clause B of subsection 1 of Section 5 of that Act, it is proved an accused has accepted or obtained or has agreed to accept or attempted to obtain for himself or for any other person any gratification other than legal resumption or any valuable thing from any person, it shall be presumed, unless the contrary is proved, that he accepted or obtained or agreed to accept or attempted to obtain that gratification or that valuable thing as a motive or reward such as is mentioned in section 161, or as the case may be without consideration or for a consideration which he knows to be inadequate. When the court is called upon to consider whether a charge should be framed or not, the question to which the court has to address itself is whether the evidence laid on behalf of the prosecution is such that if unrebutted it would justify the conviction of the accused, and the court has therefore to examine the evidence as it stands without rebuttal and come to a conclusion whether on the basis of such evidence the court would convict the accused, and where the offence charged against the accused is under section 161 or under section 165 or clause A or clause B of subsection 1 of section 5, the court must necessarily apply the presumption under section 4 while considering whether on the basis of the rebutted evidence which is before it the court would convict the accused. We do not therefore see any substance in the contention raised on behalf of the first respondent, and we must proceed to dispose of this appeal on the basis that even for the purpose of considering whether a charge should be framed or not, the presumption under section 4 must be taken into account.